come before the court. The state of Ohio will be David v. Hess. Each party will have up to 15 minutes to present their arguments. Appellant may reserve up to 5 minutes for rebuttal. And if you do plan to reserve time, please let me know so I can keep you track of the time. The arguments are being recorded, so please stay behind the podium, introduce yourself, keep your voices up. You should not use the names of children or minors or victims during your argument. Should that be relevant, you can refer to those folks by initials or terms like a child. We have read your briefs, and we are ready to proceed when you are. And counsel, I would just ask you, would you like to reserve time for rebuttal?
Yes, I would. 5 minutes.
Very well. Then you may proceed.
Good morning, Honors. Attorney Eric Hall here on behalf of the appellant David Hess. We talked about the facts a little bit. In this case, the appellant was a tenant of a single-family resident in Brunswick, Ohio. Meaning he was rented. The property was foreclosed, meaning for some reason the owner was not able to keep up with the mortgage or some other reason. So at that time, the property was sold at a sheriff's sale. That's the next step in that process. So after that happened, an eviction order was issued because there's a new owner of the property, and whoever's staying or renting there no longer can live there because there's a new owner and they don't want to live there. February 21st, 2023, sheriff went to the home of the appellant, knocked on the door of his home, so he posted an eviction notice there. That eviction notice stated that the appellant had until March 16th to be out. So what happens next in the process? Deputies returned on March 16th. At that point, the appellant was home. He answered the door and told the deputies to get off the property, to get off his property. It's not his property, but he's living there. He refused to leave. He closed the door. And so the deputies went and they had a warrant issued for his arrest for obstructing official business. That's a misdemeanor, which is the misdemeanor of the second degree. So another notice was posted which gave the appellant until March 20th to get out. The deputies returned on March 20th, and they found that the door of the property was open, which was unusual. They entered the premise. The appellant refused to leave and was placed under arrest for obstructing official business. The new owner had hired somebody, a cleanup person, to come and clean up the property. It's the usual process. During that cleanup process, the person conducting the business that does that located in a kitchen cabinet of, I think, the same dishwasher, a small box. Inside that box was suspected drugs, some paraphernalia, maybe something like a pipe that could smoke methamphetamine, and he gave that to the deputies. The substance that was tested, and it came back to tested positive for methamphetamine. The appellant denied ownership of the drugs. And a jury trial was held, and the appellant was found guilty of aggravated possession of drugs, which is a 50-degree felony, punishable by 12 months in prison. He received a sentence of community control, which is probation. 2 assignments of error, challenging the sufficiency and weight of the evidence as far as the possession of the methamphetamine. State failed to establish beyond a doubt that the appellant knowingly possessed the methamphetamine with the contents of the box. Not enough to establish constructive possession for the following reasons. One, the appellant was not present when the drugs were located. There was a cleanup person, but the appellant had already been out of the house at the video. Denied ownership of the drugs, and was not in actual possession of the drugs on him.
Counsel, was there any evidence there was anyone else in that house?
My understanding is nobody else was living there with the appellant, but as indicated earlier, the door of the residence was wide open. And the second time the deputies came, we found it to be unusual, and then the appellant was evicted, who was arrested. And so at that point, there was nobody who was not in the house, so other people could run into the house.
And counsel, was he tested when he got to the county jail for drugs?
was no fingerprint analysis to determine whether the fingerprints and Hell's fingerprints were on that box, because it would not be a great leap to believe that if it was his, and then he tested the fingerprints, his fingerprints would be on it. Of course, he tested it, and there were other fingerprints that didn't belong to him, and that was exonerating him. And again, if DNA, he found DNA on the box itself, that was not his DNA, that then was done. Again, this is a case where I would argue it's easy to prosecute somebody, the state can easily prosecute somebody without testing and doing those tests. But again, those particular tests would exonerate somebody if they came back favorably for the appellant. If somebody else's fingerprints were on the box, somebody else's fingerprints were on a glass pipe, somebody else's DNA was on that glass pipe, somebody else's DNA was on the box. Again, this is an argument of constructive possession. And the fact that he had been there before, but he was no longer there, I think is even a weaker case to establish a constructive possession. Now, when these drugs were found, he was not even staying in the house. He was somewhere else. He was in jail, or maybe released, but he had been arrested and he was essentially evicted from the property. Okay, so the owner had taken possession, and there was a cleaning company, and the cleanup company was in. They're the ones who found this in the kitchen cabinet. He was unaware of any, he didn't know anything about it, denied ownership of it. And the state has simply failed to present sufficient evidence to prove that he constructively possessed this particular drugs or the paraphernalia or the box that was found. There is a new question.
Hearing none, we will have a full 5 minutes for the call.
Thank you, Judge.
May it please the court, my name is Stephanie Zernick, and I'm from the Dr. County Prosecutor's Office representing the appellate in the state of Ohio. David Hess assigns 2 assignments of error, both of which he will here. First, there is sufficient evidence to support the jury convicting Hess of aggravated possession of drugs. The relevant statute states that no person shall knowingly obtain, possess, or use a controlled substance or controlled substance animal, which includes methamphetamine. As we discussed earlier, acting knowingly means that the person is aware that his or her conduct will probably cause a certain result or be of a certain nature. Again, there are 2 types of possession, actual possession and constructive possession. Circumstantial evidence can be used to establish constructive possession. This court has stated that although owning the premises or proximity to contraband does not establish constructive possession on their own, viewing the entire set of circumstances together may establish constructive possession. There was a great deal of evidence showing Hess's constructive possession of the drugs. They were found in his kitchen cabinet. Hess was the only person on the lease and the only person that lived in the house. Hess did not tell the deputy at the jail that he had friends or other people constantly leaving items at his house. And in addition, as was stated previously, Hess tested positive for methamphetamine.
Someone is talking there for a minute about he did not tell the deputy. He has a right to be completely silent if he wants to, right?
Yes, Your Honor, he does.
So failing to explain the presence of drugs is part of the totality of the circumstances that the state indicates means that there was sufficient and enough weight of the evidence to convict him.
He did choose to speak to the deputy, Your Honor, and even though he did not have to, as you have stated.
Okay, I get the flavor from the briefs that Mr. Hess was in some distress and that his, and we have not been able to review the record yet, but we certainly will. But I get the feeling that some of the testimony that's in the record was about his inability to control himself and inability to be coherent in his speaking. Is that what I've been finding when I take a look at the testimony?
Yes, Your Honor, Mr. Hess was very, had difficulty controlling his emotions, both when deputies came to his house initially and after Hess was not present when the drugs were found because he had already been arrested. However, the 10th District Court of Appeals has stated that circumstantial evidence can prove that the defendant exercised control over drugs, even if the defendant is not present when the drugs were found. As we just discussed, Hess argues that he told the deputy at the jail that he did not know anything about the drugs, and he freely chose to speak to the deputy. However, it is highly likely that he would choose to incriminate himself by telling the deputy that he knew about the drugs. Hess also argues that no fingerprints were taken from the box or drug paraphernalia, and no DNA analysis was done. However, the deputy testified that fingerprint or DNA analysis is only performed through the Ohio Bureau of Criminal Investigation, and that the Bureau does not do fingerprint or DNA analysis in drug cases as a policy. Second, the manifest weight of the evidence was in favor of Hess constructively possessing the drugs. Again, the drugs were found in the kitchen, a common area of the house. Hess leased the house as the sole tenant, and did not tell the deputy when he spoke to the deputy that anyone left items in his house on a regular basis. Finally, Hess tested positive for methamphetamine at the jail. The jury did not lose its way in convicting Hess of aggravated possession of drugs. Are there any further questions?
The counsel, opposing counsel has mentioned that he no longer was the owner, it was a change in ownership of the house. Can you speak to that?
Yes, Your Honor, you are correct. There was a change in ownership of the house, but as far as I know, there was no, the person that owned the house had not taken possession at that point. Hess was still the only person that had control over the house up until that point.
Thank you, counsel.
Therefore, the state of Ohio would respectfully ask this court to affirm the judgment of the trial court. Thank you.
Thank you, counsel. Mr. Hall, you will have your full time.
Thank you. The last thing the state mentioned was that the new owner had not taken possession. That's not accurate because they had taken possession through an agent. They had a cleanup crew because it's cleaned up. So they are in actual possession. You wouldn't be able to do that and put that type of person or business in there and do the cleanup unless you were in possession. So the new owner was in possession of that home at the time, and it's clear that the appellant was no longer in possession. So the new owner was exercising dominion and control over the property that they own by sending the cleanup crew. Anytime they could came in there, what they wanted to do, they cleaned up and ready for whatever they wanted to do with it, whether they're going to live there, rent it out, or sell it to somebody else.
And counsel, was this presented to him in court, this information?
I think just we briefly touched on it as far as facts. I don't think that was a legal argument that was made. I think it's important to note that the appellant, when he was being arrested, before being arrested, he didn't try to go into the kitchen to, if he had contraband there and was aware of it, to try to hide it or dispose of it or destroy it. So he didn't do that. When questioned by his Deputy Barton, he indicated that he didn't know anything about it. It was not an actual possession of the contraband. And I think, he asked about some of the issues that the appellant had as far as controlling his behavior or some things that happened. I believe a competency evaluation was, a motion for a competency evaluation was filed. The competency evaluation was conducted, and he was found incompetent to go to trial, meaning that, obviously the court understands to be able to assist his counsel in defending and during the trial and understanding what the purpose of the judge's purpose, the prosecution's purpose, the defense counsel's purpose. So he was found incompetent, but he has some issues as far as the motion issues, I guess. I just don't believe in this case there was enough evidence to establish constructive possession, especially when he was no longer the owner of this property. So, if you think about it, what if someone has left the property and it's been a longer period of time? What if the house has been sold to the owner? What if it's months later that they find some contraband? Does that mean that the person who had previously lived there is going to be charged with constructive possession and something that they've been separated from that home for a number of weeks, months, maybe even years? That seems to be